This is Harney's Offshore Litigation Podcast. My name is Ian Mann, and I'm delighted to announce that I'm being joined by my colleague here in Hong Kong, Julie Engwirda. Welcome, Julie.
Thanks, Ian. It's great to be here.
The topic for today, which sounds dry, but we're going to make it sound interesting, is, well, it says derivative actions, but I think that's too easy for you, Julie. I would like you to talk about, please, multiple derivative actions too. And I think it's right that you have actually lived in the BVI for 11 years, haven't you? So you've been really, before moving to Hong Kong, you've been at the coalface of this sort of stuff.
Yeah, absolutely. And interestingly, with these derivative actions, I arrived in BVI in 2005, which is when the BVI brought in the Business Companies Act, and that's what brought in the statutory derivative action process. So having spent the next 11 years in BVI, I really got to see how this law's developed.
And I mean, the BVI courts look to English law for guidance because the English statute does have provision for derivative action. So that's quite helpful, isn't it?
Yeah, absolutely. But as with all different jurisdictions, there's some sort of subtle tweaks that can throw up a few complexities with these things. And you know, there's a couple of subtle differences between BVI statute and English statute that can trip people up if they're not alert to it, and makes life interesting.
And these derivative actions are just part of the armory, as it were, I guess, for a shareholder who feels badly treated in a company, because you've got a number of options. You've got unfair prejudice claims, just and actual claims, derivative actions. Where does derivative actions fit in a shareholder's armory, as it were?
Yeah, look, it is really often seen as a port of last resort, and that's because the Business Companies Act does arm shareholders with so many powerful tools to seek relief. For example, an often overlooked provision is Section 184B of the Business Companies Act, and that gives shareholders power to force compliance by directors or companies when they're not complying with the M&A. Now, derivative actions, of course, come in where the wrongdoers are in control of the company.
Yeah.
And those wrongdoers aren't protecting the company and enforcing rights or harm that's been caused to the company. And that's where the law steps in and arms them with this very powerful tool to ensure that the company is protected and that any wrongs committed on the company can be put to right.
And we're just going to focus on the BVI, I think, in this podcast, because BVI is complicated enough, actually, without talking about other places. Okay, fine, perfect.
Absolutely.
And I mean, why, people often say of the BVI that they have, for derivative actions, there is all this legislation, but there's been quite a lot of movement in the case law, hasn't there? Because there was this debate, wasn't there, that on the one hand you have all of this fancy legislative provision, but there was this sort of unease that there still existed the common law right for derivative actions, which need not obey the rules of the new legislation. Have I mischaracterized that?
No, not at all. And it's one of the interesting things with jurisdictions like BVI, because they're developing and they're innovative and they have such an appetite to find solutions. The court's very willing to examine around what the options are. So originally, when these cases were first arising, there was a very strict interpretation of statute that you can only bring a single derivative action. So that's where you're a direct registered shareholder of the company. Now the courts are moving on from that position, and they're recognising that just because there might be a restriction in the statute doesn't mean that that's abrogated what your common law rights might be. So where the common law gives you a right to bring a multiple derivative action, for example, or recognises, say, the rights of a beneficial owner, somebody who's not on the register.
Really?
Why shouldn't the court intervene and give assistance?
Well, so a nominee, I mean, this happens in Asia a lot, so a nominee who refuses to try to procure the derivative action just gets sidestepped, and the beneficial owner...
It's not as simple as them being sidestepped. There's mechanisms that have to go through. But the court's certainly showing a willingness not to shut out beneficial owners just because their nominee or the person who's on the register is refusing to take the necessary steps to protect those rights. And again, that's a long line of authorities in BVI, and there's been a lot of developments around this area over the years.
Well, just to show
it's a podcast in itself.
Just to show I've done my preparation, I've got this BVI textbook in front of me.
Fantastic. Who wrote that? that.
all the proceeds go to charity now, Julie. But this issue actually goes to the Court of Appeal, doesn't it? In a case called Tip Investments, and they're talking about a sort of trust dispute in relation to a beneficial owner, and it was that sort of left it open for beneficial owners to proceed.
And Tip's it's a really interesting case because it examines a number of different concepts. So it examines the locus of the beneficiary in order to actually bring the proceedings. It examines derivative actions. It examines common law multiple derivative actions. And the Court of Appeal, the Eastern Caribbean Court of Appeal, recognised that the beneficiary shouldn't be shut out. And they recognised also that based on a line of authorities from the UK, that trust claims can have the ability for a multiple derivative action. Now, when you follow that through, should it be restricted to a trust claim? We've seen before where the BVI courts have been very willing to enforce and give a party a right to enjoy a common law remedy when the statute appears to shut them out. We've seen that with developments around insolvency law. So I think the next logical step in all of this is that the court's going to be very open-minded to it and start to be more flexible in its approach and seek to give assistance.
So for Ian Mann's sort of cheat sheet, for my small brain to remember, essentially under the legislation it's only a single derivative action that's available, but there is the door open under the common law for a multiple derivative, and that would include possibly, because of this Court of Appeal case, beneficial owners as well.
That could possibly extend, yeah.
Now, what about, we've had someone write a little question for me to try and trick you, and that question is, are multiple derivative actions used essentially to avoid key jurisdictions, key courtrooms that they want to avoid by using this multiple jurisdiction route? Is it open to abuse?
Look, I think any legal mechanism can be open to abuse. That's, we see that time and again, and we see legitimate uses of processes. And BVI, as well as other jurisdictions such as Cayman, have these structures which are quite complex. And it's not unusual to see, say, a BVI company with a Cayman subsidiary, with another BVI company, within a Hong Kong company, and a PRC entity. Now, if you're a shareholder of that top BVI company, why shouldn't you be able to try and go through that chain and enforce your rights lower down? Now, that brings up all sorts of interesting questions around, well, in which jurisdiction do you sue? If you're suing on behalf of the Hong Kong entity, do you actually need leave from the BVI court, first of all, to go down through that chain? Do you need intervening leave from Cayman? How these processes get resolved is going to be really fascinating to see the development.
I mean, just to theorise, you could have a multiple derivative action that needed multiple, to use the modern expression, permission or leave, to use the old-fashioned expression, from multiple courts.
Absolutely.
Right?
And what happens if one court rejects it? You might have a very open court, say BVI, if you've got an intervening company sandwiched in there who's willing to allow this. But what if that intervening jurisdiction doesn't?
And I mean, there is this case of CHC Investments, which was a case where it involves a Hong Kong listed company seeking permission to bring a derivative action. And as part of the defence of the permission, it was said they're not really bringing in good faith. It's just a sort of stratagem, a tactical question. So the courts are, when granting leave, and you do need leave, the courts are looking at obviously the merits, the prospect of success, but also at the good faith. There's a good faith requirement, essentially.
Yeah, absolutely. Yeah. And look, that's embedded in the statute.
I see.
The statute very clearly sets out a roadmap for what you have to show the court in order to satisfy it, that a derivative claim should be brought. And there's no reason to suggest that those statutory issues wouldn't also apply in common law. That's where they had their derivation. So showing good faith, things like that is going to be key.
So bringing a claim in Hong Kong, derivative action of a BVI company, you still need to get permission from the BVI court because that's the place of incorporation, right?
Yeah, absolutely. And there was the first case on all of this was Vardam, and it was proceedings commenced in California. And they hadn't sought leave to start with for the BVI company.
So they got burnt.
And that's sort of where it starts, and that's where the developments in this law began.
Well, exciting times for shareholders. More options for them, and something to remember. And it allows many different lawyers from jurisdictions to sort of get knock their heads together to think of the best strategy. Julie, thank you very much for your time. Will you agree to come again?
Absolutely.
Thanks so much.
Thanks,
Cheers,
Ian.
Julie. Bye. Bye.